Islam. Islam, Islam, Islam. Islam, Islam, Islam. Come on in, we in here. Grand Rich Rising, we in here. Grand Rich Rising, we in here. What's the word? Grand Rich Risings. Rise of the Moors. Let's do it. I'm here. As promised. I'm back with another one when I ain't think I had another one. Let's talk about the habeas corpus. The habeas corpus get people out of jail. Get custody of your kids. We talking about getting custody of them kids. Anybody got a custody battle they dealing with? I'm finna give y'all a free class today on how to get custody of them kids. Jason Bush has said, "What up? What up? Yeah, what up, Jason? What up, Jason Butcher? Let's go." Why is it still showing the old chat? Let's go. About to go mow grass. Before you go mow that grass, you want to catch this class. Don't miss this class. I'm finna drop on a habeas corpus, child custody. Let's talk about it. All right, how many people you know can get custody of their child from their baby mama or they or their baby daddy or um child protective services? This class for you. You got to deal with child protective services or DCFS or child support. Anybody playing with custody of your child, I got the remedy for you today. I got it for you. It's called the habeas corpus. It's called the habeas corpus. Let's talk about it. I'm trying to set this to I should be already in there. Let's talk about it. All right. Let's go in on it. Now this is a free course we giving out on the Conscious College. When you come to the Conscious College, you get this course for free. All right. This is the habeas corpus to get custody of your child. We teach you step by step. I can't screenshot on TikTok, but if you're on my Facebook, my Instagram, my YouTube, then you see any screenshot. Go YouTube, faithful member. All right, let's talk about it. Habeas corpus for child custody. Now, if you got problems with child protective services, you got problems with your baby mama or baby daddy keeping your child away from you. The remedy is called a habeas corpus. You spell that Habeas corpus, Corpus. Let me go get my glasses so we can read this. Islam. Let me get my glasses on so we can read this. Islam. Now we dealing with child custody, habeas corpus to get your child back. I'm gonna give you step by step on what you need to do. All right, I'm gonna get you step by step when you dealing with custody, cause it's dealing with equity. I'm gonna teach y'all true equity today. All right, equity is who has the highest interest in the child. The parent always has the highest interest in the child, cause you biologically You biologically have interest in the child because that's your biological child. You understand? Let's get to it. Let's get to it. All right, habeas corpus for child custody. A writ of habeas corpus is a legal tool that a person can use to enforce a superior right of possession to a child. In other words, if you have the legal right to have a child live with you and someone else is without that legal right is keeping your child away from you, you can ask the court to order that person to return your child to you. You understand? That's the power of a habeas corpus. If you have the legal right to have a child live with you and somebody else without that legal right is keeping that child away from you, you know what I'm saying? You can ask the court to order the child be returned to you. All right. So this is a kit we giving you at the Conscious College. All right. When you use this kit, you have a custody order. Uh, you can use this kit if you have a custody order giving you legal right to the child, or another person is keeping the child from you in violation of that order, or you are a parent and you have not been able to get your child back from someone who is not the child's parent. You have been served with a petition for habeas corpus, and you think the child should be returned to the person who filed the petition. So these are the three ways, you know what I'm saying? If you got the legal right, court order, custody order to have a child, or you the parent and somebody who's not the parent is keeping this child away from you, then this applies to you. You know what I'm saying? This applies to you. All right. Where should you file my petition for a writ of habeas corpus? All right. We're going to deal with Texas State. You can file a writ of habeas corpus in your state. This is a state court uh procedure. You don't have to go to federal court for this. You go to right to your state court to file the habeas corpus. All right. So states that the petitioner may file a petition for a writ of habeas corpus in either court of continuing exclusive jurisdiction or a court with jurisdiction to issue a writ of habeas corpus in the county in which the child is found. So wherever the child is, then you need to start there. All right. Whatever you found the child, then you need to issue the writ. So you might have a child not living in your county. So you have to go to that county and file the writ of habeas corpus. You can do this by mail. You ain't gotta drive. I be hating to see people drive all the time to these locations. You can just file a case through the mail. Certified mail. It has to be certified mail, and you send it to the clerk of the court. You know what I'm saying? With the proper paperwork, your petition, your applications, you know what I'm saying? Your cover letter, all these things you can send us by mail and file your habeas corpus in the county which the child is at. All right, let's talk about it. Can I file a petition of writ of habeas corpus for multiple children? I say if you got multiple children, what should you do? If the children have the same legal mother and father or legal managing uh, conservator, it may be possible to include all the children in the same petition. You know what I'm saying? But if there are separate conservatorship orders for each child, or if the children have different parents, it may be necessary to file different petitions for each child. The petitioner will have to determine if he or she has superior right of possession to each child individually. So if you got multiple children and you want to do a habeas corpus, and they about different, say they different about different fathers, different mothers, or different institutions have them, then you might have to do a separate habeas corpus for each child. All right, let's talk about it. Let's talk about it. I'm gonna get y'all right today. Okay, we got a question on the floor. Stasha Marie say, if there is no official custody order, which this still suffice? Yes, this still suffice because this deals with anybody who has the right, superior right of possession. That's what it deals with. So would this suffice against another parent? No. But this because if you going against another parent, then all you have to do is file a visitation order. That's all you have to do. If you have another parent that has equal rights as you, because parents have equal rights, and if you have another parent that you that's depriving you of seeing your child, all you have to do is file visitation in the exclusive jurisdiction family court. All right, that's exclusive jurisdiction. You can file visitation. But this would suffice if there is no custody order. You don't have to have a custody order if you're the biological parent. All right, but if you're not a biological parent, then yes, you got to have some type of order, you know what I'm saying, to claim some other child that's not biologically yours, or you didn't get them through, you know what I'm saying, no type of adoption, and you don't have no proof of you having interest in it. It's all about equity and interest. So if your child is your biological child, you by birth have custody of your child. You have the highest interest to your child. You know what I'm saying? Because you biological the parent. You see what I'm saying? So um you don't have to worry about a court order if you biological parent. You know what I'm saying? So who is considered a parent of a child? So Texas Family Code describes what was considered a parent in 160.201. So if you're in Texas or whatever your state is, look up the state family codes for this type of information. Your state family codes is where you're going to find this type of information about custody of your child and how to use these laws to have custody of your child. All right. So Texas Family Code 16201 lists out the ways that a parent-child relationship can be legally established. So you got to understand this is equity. This is a parent-child relationship. Anytime you have a relationship of any to equity, because it falls into an agent principal relationship or something fiduciary relationship. So you have automatically, you know what I'm saying, you already have guardianship over your child, which is a legal status. Guardianship is a legal status. All right. So I'm gonna continue reading. It says a mother who is someone who gives birth to a child, adopts a child, or is found by a court to be the mother of a child. So, okay, so you consider a parent a mother if you adopted the child, you birthed the child, or you got a court order saying you the mother of the child. A man can be legal father by presumption, acknowledgement, or by adopting the child. All right. Or if he is found by the father by a court, adjudicated. All right. So as a father, it's a little bit different for us to have father rights because we either have acknowledged that we the paternity with a voluntary acknowledgement agreement, or you have to um, adopt a child, or you have to have a court order, or you already presume to be the father by presumption. You know what I'm saying? Everybody already presume you the father, then you the father. You know what I'm saying? Just how it go. I just seen brothers pay child support for stepchildren. You know what I'm saying? For stepchildren. I've seen people brothers pay child support for children they didn't even have. You know what I'm saying? It was somebody else's child. You know what I'm saying? And the mother told them that was their child, and they found out later it wasn't their child. And they still had to pay child support. All right, because you, as a father, you presume the father. You know what I'm saying? All right, let's talk about it. How do I prove that I'm the parent of the child? Okay, a legal mother can prove she gave birth with a birth certificate bearing her name. An adoptive parent can provide a certified copy of adoption decree. An adjudicated parent can provide a certified copy of the court order. All right, so a mother to prove, you know what I'm saying, that she's the mother or a parent of the child, all she have to do is show a birth certificate or a certified copy of an adoption decree or certified copy of a court order. You understand? That's all she have to do. Um, Acknowledgement of paternity. You know what I'm saying? Uh, Now, as a father, it's a little bit different. It says, in general, a presumed father can provide a certified copy of a marriage certificate and birth certificate. However, there are other more complicated situations where man may be presumed father. If you are unaware if you are a presumed father, you should speak with an attorney. You understand? For a man, like I say, you can have some type of court order, you can have a birth certificate bearing your name on it, or you can have a paternity acknowledgement, uh, acknowledgement. You know what I'm saying? Acknowledgement of paternity, I should say. Acknowledgement of paternity. You know what I'm saying? Proves that you the father. All right. Let's talk about it. What type of court orders can rely on to prove a superior right of possession. Now, this the good right here. You know what I'm saying? What kind of court orders can you rely on? You know what I'm saying, to prove you have superior right of possession. I say if you're not biological parent and you need a court order, what type of court orders can you rely on? You know what I'm saying? In Texas, an order in a suit affecting parent-child relationship would generally say who has the superior right of possession. This include a temporary or permanent divorce order, originally SAPCR order or modification order. If anyone has ever set up child support through the Texas Attorney General's office, there is likely a court order for conveyorship and possession. An adoption decree will also generally say who has superior right of possession. A judge can only order the return of a child based on the order granted in a proceeding where parents were given notice and an opportunity to be heard. For example, a temporary restraining order may not be sufficient to compel the return of a child if it was granted ex parte without notice to the respondent. Sometimes a parent may sign a power of attorney or authorization agreement for care of a child and give temporary permission for a non-parent to care for a child. This is not the same as a court order and cannot be the basis for a petition for a writ of habeas corpus. All right. When must a court order that child be returned to the petitioner? Let's talk about you want to custody your child from CPS. I'm giving it to you right now. We got a free course in the Conscious College. When you pay your subscription, $49.99 per month, you know what I'm saying? We giving out free courses, free information that comes with it. Plus, you got Sunday school. Let's talk about it. When must a court order that child be returned to the petitioner? If the court finds that the petitioner has superior right of possession, the court must grant the return of the child to the petitioner in the following circumstances. If the petitioner has superior right of possession under a court order and the petitioner has not relinquished possession of the child for at least 6 months before the case was filed, and there is no serious immediate question concerning the child's welfare. Number two, if the petitioner has superior right of possession by law as a parent and the respondent is not a parent and no SAPCR is pending, and the petitioner has not relinquished possession of the child for at least 6 months before the case was filed, and there is no serious immediate question concerning the child's welfare. The court has discretion, meaning the judge can decide to return the child to the petitioner or not return the child in the following circumstances, even if the petitioner has the superior right of possession. The petitioner relinquished possession of the child for at least 6 months before the case was filed, or there is a serious immediate question concerning the child's welfare, or a SAPCR is pending and the parties have already been given notice that a hearing on temporary orders is set for the same time as the hearing or writ of habeas corpus. All right. Note, if a SAPCR is already pending in your situation, you should speak with an attorney before attempting to use this kit. You understand? All right. Now the next question is, what counts as a serious immediate question concerning the child's welfare? It says this is up to the judge to decide. However, in general, it means that immediate actions is necessary to protect the child from imminent danger of physical or emotional harm. Different courts have interpreted this in different ways. If you are unsure how this applies to your situation, speak to an attorney. You understand? Islam. Nobody said, what house are you out of? I don't even know what that means more. What you mean, what house am I out of? I'm on my own house. I'm out of the house of David. Islam. I'm from the house of David. Islam. All right, let's keep going. We went through the frequently asked questions. So now I'm gonna give y'all instructions on how to file a habeas corpus. All right, I'm gonna give y'all instructions on how to file a habeas corpus. Drop a 100 if y'all still there. Drop a 100 if y'all still here with me this morning. It's too early for y'all or what? Y'all ain't got no questions? Drop a 100 if you still with the Grand Sheik this morning. You want to learn instructions on how to file a habeas corpus. Angie Wordsworth. What's up, Angie? You always there. soaking up that game. On Regis Welch, what's up? Drop the 100. William Quinn, drop the 100. Drop a 100 if you with me. Stasha Marie, drop the 100. That's what I'm talking about. Let's go in now. Drop the 100s if you with me. All right, let's drop these instructions to file a habeas corpus. All right, this is the instructions to file a habeas corpus. All right, okay, these instructions explain the steps to request a writ of habeas corpus in the order returning a child. These instructions are for the petitioner, the person who opens the case and files the petition. So the petitioner is the person who files this petition. You petition, you asking the court for permission to return your child. You know what I'm saying? All right. This is now before I start this, these instructions provide general information. It's not legal advice. It's a good idea to talk with a lawyer about your particular situation. You understand? All right. So let's go through the checklist steps. All right. Step one, to file an habeas corpus, complete your forms and attach the exhibits. That's step one. Petition for habeas corpus. Okay, this form is filed by the petitioner, the person filing the case, and tells the judge why you have a superior right of possession to the child. It also asks the judge to issue a writ of habeas corpus. All right, ordering the respondent to bring the child to court for a hearing. So when you come in equity, um, it's a petitioner. The parties is not plaintiff and defendant. It's petitioner and respondent, because we come in because you have a superior right, titles, and interests over my child, which is called your estate. Your child is your estate because you have rights, titles, and interests. All right, this is equity law. Who you know gonna teach you equity law when it comes to your child? Huh? I am. That's who Grand Sheik tap in with the Conscious College. That's who gonna teach that. Conscious College gonna teach that. All right, let's talk about it. To fill out Section 3, court order for conveyorship of the child, you must first determine whether a court has ever issued an order for possession regarding the child that you want to return. All right, so first of all, you gotta first step, you gotta complete the forms and attach the exhibits. But if you have a court order, you know what I'm saying, you must attach that court order. But if you don't have a court order and you're a biological parent, you don't need a court order. All right. If there's a court order for possession and you are claiming superior right of possession because of that order, select option 1 and attach a certified copy of the order to your petition. All right. So if you got a court order, smoking gun. If you biological parent, it's smoking gun. All right. All you got to do is attach your exhibits. You know what I'm saying? So you're going to file the petition, which is like an application. And that's in the Conscious College. We give you the template for this. All right. You're going to fill it out with honesty and good faith, right? Honesty and fact is good faith. So you're going to come in honesty and fact. You know what I'm saying? And you're going to attach your exhibit to it to prove what you're saying. All right. You know what I'm saying? Uh, Dr. Turner L said Islam. Islam, Islam, Islam. Let's talk about it. Regis Wells says set me as an admin. All right, let me see how to do that. I gotta figure out how to do that, Regis Wells. We're gonna work on that, setting you as an admin and help out with these negative trolls, man. You trolls, I got something for you, boy. Keep on trolling me. Make yourself a target. All right. Now let's talk about it. If there's no court order and only a legal parent can file a petition against a non-parent. If you are a legal parent, select option 2 and attach proof that you are a legal parent of the child. So I went over what is proof, you know what I'm saying? What is proof to prove that, you know what I'm saying, you have the highest interest of the child. Just prove you the parent. If you a mother, that's easy. You know what I'm saying? Your birth certificate proves that. You know what I'm saying? If you're a father, birth certificate or acknowledgement paternity prove that. You know what I'm saying? Or some type of presumption. You was married to the girl, some type of proof. You know what I'm saying? That's all you got to touch your proof to this. All right. Let me give y'all a tip. All right. Because court orders can be long and complicated, it's a good idea to highlight or mark the sections that explain who has superior right of possession to the child so that the judge can review it more easily. You understand? Make it easy for the judge. You know what I'm saying? Make it easy for the judge. You know what I'm saying? Make it easy for the judge. Go and highlight the section you know what I'm saying, that says, okay, I got superior right to this. You see what I'm saying? Gonna highlight that for the judge. All right. I go another tip. All right. Uh uh it is very important that the respondent's legal name and address you list on the petition is correct. If the respondent cannot be served, he or she will not know to bring the children to court for the next hearing. You understand? Who is the respondent? The respondent is the person who is holding the child illegally, either because a court order says you have a right, superior right of possession, or you are a parent of the child. The respondent is not a parent, and there is no court order. All right, there's no court order. You understand? Um, you know what I'm saying? Or you have a court order says you have superior right, and this other person doesn't. Then that's the respondent. That's the respondent. You the petitioner, they the respondent. All right, let's talk about it. Order for the issuance of a writ of habeas corpus. Okay, it says you do not know if the judge will issue the writ of habeas corpus. However, it is good practice to fill out the order for issuance of writ of habeas corpus, and if the order is granted, the judge will sign it, and the judge or the clerk will fill it out, the portion that says the date, time, and place of the next hearing. So when you're doing your petition, you should have your petition, you should have your exhibits, and then the next thing you should have is the actual court order for him to sign. You know what I'm saying? You should have a court order from him to sign. You get what I'm Step two, file the forms and present it to the judge for ex parte review. So ex parte review is that you don't have to serve this on the other party. This is not, you know what I'm saying? This is not for the other party um to present arguments from both sides, because if you have the superior right, you know what I'm saying? If you got the superior right, ain't no arguing for the other side. All right. uh Dr. Turner ill saying, box me some lessons, Grand Sheik, so I can study and demonstrate Islam. Come join the Conscious College. We got all law library, we got videos recorded, we got abundance of information in the Conscious College. All you gotta do is hit the link in the bio. Hit the link in the bio. It's only $49.99. Send me a cash app. You know what I'm saying? Send a cash app, $49.99. Uh, and I'm gonna get you right. Every Sunday, we're going in tomorrow for Sunday school. All right, let's talk about it. Uh, it says contact your clerk's office for information on how to do this. Your county may require a certain judge to review your paperwork, or you may be able to take your paperwork to the duty judge who is available anytime. The judge will review your petition and any exhibits ex parte, meaning you will not be present. You know what I'm saying? So you don't have to be present for when the judge review it. Like, you don't have to necessarily have a hearing for him to make a judgment on it. You know what I'm saying? Habeas corpus. I know a lot of y'all be like, man, I don't want to go to court. I don't know what to say. I need a lawyer. Well, when you're dealing with the habeas corpus, you don't even have to go to court. You know what I'm saying? You don't even have to go to court. All right, Chief Big Wanna say y'all will not be disappointed joining the Conscious College. Let's talk about it, Chief Big Wanna. Let's talk about it. You know what I'm saying? You're not gonna be disappointed joining Conscious College. We going in, and the lessons get better every week. They get better every week. I'm trying to tell you. All right. It says if the judge grants your request to issue the writ of habeas corpus, the clerk should prepare the paperwork for you and make arrangements for the writ to be served on the respondent. Make sure to review the order granting the writ of habeas corpus after it is completed by the judge, so that you know when the next hearing is set for. Mark the hearing in your calendar and make sure you have a reliable source. So don't be late to court. For the habeas corpus, they will dismiss it because you, the petitioner, don't have an attorney. You know what I'm saying? You know what I'm saying? Step three. Step three, the focus of the habeas corpus hearing is very narrow. It is limited to who has superior right of possession of the child. So, you know what I'm saying? Habeas corpus is pure equity. It's pure state law. It's about who has the highest superior right of possession. Your right is your estate. Your rights, titles, and interests is your estate. All right. So this falls into estate law. All right. Whose estate is this? Whose estate is this? Let's talk about it. Let's talk about it. Uh, we got a question on the floor. Um, Deanna the goddess said, "What if the respondent is the other parent and there's a court order in place?" Well, see, if the other parent is uh the biological parent and that's a court order in place for right of possession of the child, then you can file the habeas corpus if it is, you know what I'm saying? If it is, but if it's not, right, say if the essential custody of the child, parent, all you have to do is file for visitation. You don't have to do a habeas corpus. All you have to do is file a motion for visitation. That's it. It's way easier to do that because you got to understand, as a mother and the father, y'all have right possession to the child. You cannot take a child from his father. You cannot take a child from his mother. If you have visitation where both parties, you know what I'm saying, both parties have equal rights. That's how you do that. You do a visitation or for a parent, not a face. So say if it's a and the divorce decree is going to outline the visitation rights. It's going to outline the superior right of possession. It's going to say who has residential right over the child. You know what I'm saying? So for you to switch residence of the child, first of all, it has to be some imminent danger of the child. It has to be for the child's welfare. You know what I'm saying? If you wind this back, I kind of went, see what I'm saying? Like, it's about the child's welfare when you with the with the other parent, y'all rights is equal. But you gotta understand, if the child is being physically or emotionally abused, you see what I'm saying? Then y'all are not equals. You know what I'm saying? Y'all are not equals in the situation. Um, you gotta understand. Um, I hope I answered your question, but yeah, if you dealing with the other parent having a right to the child, then you just file the visitation. Now, if they, you know what I'm saying, they violate the visitation order, then the judge can order them to be for violation of the court order. You see what I'm saying? So habeas corpus doesn't apply necessarily for the other parent, all because it's easier. It's too easy for the other parent. You just file visitation. You know what I'm saying? So the respondent has a right to file a written petition. They must file the response before the hearing, and you should receive a copy of it. The response explains why the respondent thinks the judge should not give you the child back. If the respondent files a response, review it carefully to know what the respondent will try to argue in court. See the common question section for more information on what a respondent may claim. You know what I'm saying? Prepare any evidence that you think you need to present. If you plan to testify, all right, return of your child. Prepare your proposed order granting or denying return of child. You can fill in the information you know, such as the case number, the court names of the parties, and names and birthdays of the children. When you attend court, be ready to write down what the judge says because you may be expected to fill out the rest of the order. It is a good idea to bring an extra copy of the order if the judge wants to look at it. All right. So once again, when you doing your paperwork, come with the court order with it. That way it just make it easy for the judge. Like, just sign it. You know what I'm saying? I'm showing you I got proof. I got right of possession of the child. You know what I'm saying? Superior right of possession of the child. And ain't in order. You know what I'm saying? It's that easy. It's that easy. Therefore, attend the hearing. At the hearing, both you and the respondent will have an opportunity to explain what you want and present any evidence that supports your position. Attend this hearing. If you do not, the judge may not be able or willing to return the child to you. If the court finds that the petitioner has a superior right of possession, the court must grant the return of the child to the petitioner in the following circumstances. You understand? Uh, Number one, the petitioner has superior right of possession under a court order, and the petitioner had not relinquished possession of the child for at least 6 months before the case was filed, and there is no serious immediate question concerning the child's welfare. Do you understand? So if the petitioner has superior right of possession on a court order and you haven't relinquished that possession of the child, you know what I'm saying, then habeas corpus can be used. If there's no serious immediate question concerning the child's welfare, then you're going to win. But if there's any problem with the child's welfare, you know what I'm saying, mentally or physically, the judge is not going to rule in your favor. Number two, the petitioner has superior right of possession by law as a parent, and the respondent is not a parent, and no SACPCR, pardon myself, is pending. And the petitioner had not relinquished possession of the child for at least 6 months before the case was filed, and there is no serious immediate question concerning the child's welfare. See what I'm saying? So the petitioner has superior right of possession by law as a parent. See what I'm saying? And you can use the habeas corpus against a non-parent. You know what I'm saying? Or if it's some type of situation where they have a court order on you, or it might be a situation where you relinquish possession of the child. All you got to do is wait 6 months. If it's been 6 months, you can still go file the habeas corpus, even if you relinquish possession of your child. You know what I'm saying? You gave the other person power of attorney or some type of power over the child. You know what I'm saying? You gave them authority to have your child. 6 months is the deadline. They can only keep your child for. And the judge can decide to return the child to the petitioner or not return the child. In the following circumstances, even the petitioner has superior right of possession. Number one, the petitioner relinquished possession of the child for at least 6 months before the or that concern the child's welfare or SAPCR is pending, and the parties have been given that are set for the same time as the hearing on the writ of habeas. All right. So step 5. Return the child. If the judge orders you to return the child to the petitioner, you must follow the court order or you risk being held in contempt of court. Penalties for contempt can include fines, fees, or jail time. Pardon self. The judge will give you specific orders about where and when the child should be returned to the petitioner. It could be immediately after court or it could be at a later time or date. It is important that you clearly understand the judge's order. All right. If the court denies the return of the child to the petitioner based on a serious immediate question of welfare or because the petitioner relinquished the child for over 6 months, you should speak to an attorney about whether to file an original SAPCR or a modification to get appropriate conservatorship orders for the child. If the child has been abused or neglected or is in danger of abuse or neglect by the petitioner and you cannot afford an attorney, you can contact the family helpline for legal information. If the child has been abused or neglected or is in danger of abuse or neglect by the petitioner and you cannot afford an attorney, you can contact uh, so once again, you know what I'm saying? Um, this situation, this is the steps on, you know, with Join the Conscious College. You have free access to these steps and we give you the forms. The forms you're gonna need is the petition for the writ of habeas corpus. That's number one. Then we give you the order. You know what I'm saying? Like we say, the order granting the issuance of the writ of habeas corpus. You're gonna put that in there. You're gonna put the order of granting your return to your child. You're gonna put that in there. You're gonna put the civil case cover sheet. You gotta put that in there. And then the most thing you wanna put in there, you know what I'm saying? You gotta understand that this costs. So you wanna put your fee waiver in. Yeah, let's talk about it now. You understand me? Um, Jump in every week. That's what we talking about. You know what I'm saying? We talking about how to enforce your rights. We got Sunday school tomorrow. Y'all a brief remedy. Y'all might think as Child Protective Services has a superior right of possession. You know what I'm saying? You got to understand possession is 9/10 of the law, and everybody don't have the right of possession. Just because you have possession of something don't mean you have the right of possession. You know what I'm saying? You got to know what your estate is. You know what I'm saying? Uh, you got to know what things is. We got some people live, man. Y'all go live with me. Request again, let them speak some truth. If you a troll, you're gonna get removed. I'm telling you that right now. But if you want to speak some truth or ask some questions on the flow, send them. I'll let you go. You understand me? I don't know how to really, you know what I'm saying, mess with this. I don't know how to really mess with this TikTok too much. So you gotta pardon me. You gotta pardon me on this, man. But it's all about superior right of possession. You know what I'm saying? So hope y'all gain some info. Conscious College, check in with us. Sunday school, you don't want to miss it. We going in about jurisdiction, file a motion to dismiss, lack of jurisdiction, what's your constitutional rights. You know what I'm saying? I'm talking Sheik of the Moor of America, another college, signing out. Peace and love.